Kleinheisterkamp. I am teaching at LSE since now exactly 10 years. My specialism is international contracts, international dispute resolution, which is something we only teach at the master's level. However, my background is also comparative law, and comparative law from a private perspective, which means contract law. So I've been working on comparative contract law for a number of years, and also before coming to LSE. So when I was hired, basically the idea was, what are you going to teach? And I thought, well, maybe comparative contract law. They said, no, you can teach English contract law. So I started with that. One important thing about me is that I'm a German-trained lawyer. And in Germany, we do not have essay questions. We have all our 5 years of lawyer training is really about solving problems. For the students, it's quite a challenge. When students come from the A-levels to university, what they are used to is indeed writing essays. They are used to arguing. They're weighing arguments against each other and taking a position, defending that position, like in a mooting competition or in a debate. Having to solve a problem feels more intimidating. It's typically something that expects a result. It's almost like mathematics. So sometimes when students or prospective students ask me whether they should study law, I sometimes ask them, you remember your math class when you have this kind of situation like Tom drives westwards at 30 miles per hour and John drives eastwards at 16 miles per hour. They're 50 miles apart. When do they meet? That's the kind of problem question that everyone hated at school. However, law is a little bit like that. So law requires us not only to think about principles, but also to think about the actual outcomes, which means law has to be delivering an outcome. It is made for delivering an outcome. So we expect lawyers to actually be able to say, if the facts are this and this and that way, the law will tell us you can do that, you cannot do that. And that kind of analysis is something which is specific to law. And it's basically based on logic. There's no rocket science to it, really. One of the basic requirements in this is to first understand the facts. So you first have to go and read your case and read what the facts are and understand what kind of problems can arise from that. And in that analysis on finding out what actually can be problematic in this, what requires legal analysis, that can be guided by questions that are very simple. You can ask yourself first, who wants something? Because a legal claim is always brought to change the status quo. It's always about changing the situation as it is. My friend Agi and I have a dispute over a laptop, which I claim to have sold to her, and I'm now claiming the money. She denies owing me the money. So we will have to figure out what are my claims, Jan's claims, and what might be Agi's claims against me as well, right? It could also be that the laptop is actually broken, and then there are other consequences which come from that. And the question then is, are the requirements met that the law sets for this kind of transaction, for example? So you would start looking through your problem by looking at who can claim possibly something here. And typically we have scenarios where there's either only two persons, and maybe both of them may be entitled to some kind of right, but there could also be more people. And asking the question, who is entitled to something, is also important when we have more complicated scenarios, like, for example, an agent coming in, someone representing someone else in those relations. For example, when you have children involved, children themselves cannot bring a claim, their parents can bring a claim. Is it, however, the child who is entitled, or is it the parent who is entitled who will be bringing the claim? These kind of reflections are something you have to have at the very first stage. So you look at who can claim something, and then you would ask against whom they can claim something. So it is always about teasing out who is entitled and who is obliged, who has a right, who has an obligation. And the next step is then to say, well, what do they actually want, right? So someone wants something, what do they actually want? Do I want payment of money? Do I want transfer of your laptop to me? Do I want you to take a specific action? Do I want you to abstain from something? And then I have to figure out what kind of remedy does a law provide for what I want, right? What is the legal basis for that? So I first analyze the facts and finding out who wants what from whom, and then I need finally the legal basis for that. Once we have identified who wants something and what they actually want and against whom they want it, then we are able to actually bring in the law. Then we have to look at what is the legal basis that could change the present status quo. What provision in the law allows a judge then afterwards to conclude, yes indeed, AG has to pay £100 to Jan? That would have to be, for example, because we concluded a contract. I sold you my computer and you owe me the £100 for the computer. Which means if I want to claim that money from you, I would be obliged to actually show that you have consented to my offer of selling you my computer. Because if you have agreed to that, we ultimately have a contract between each other, and that will oblige you under the law to actually pay the money. If we have that perspective of looking at who is claiming what from whom, from which other person, then we are able to identify which legal provisions gives the claimant what they want to have. And then we really start the analysis, because the law, as I just sketched, provides for requirements. When can Jan claim money from AG? When the conditions for a contract are met. So we go through that and we can then apply the facts to the law. We see whether there has been consent, whether there has been a proper offer, and so on and so on. Then it might be that you deny that you owe me anything. You would say, yes, I agreed with Jan to buy his computer. However, he forced me into it. He coerced me into it. He pointed with a gun at me when I signed our contract to sell the computer. That would be a case of duress. But that would mean that then you have to prove that that duress was actually present. And we have to go through what then you learn about duress. What are the conditions for the law to recognize duress as a ground for then avoiding the contract? All of that is always the exercise of bringing together the facts with the law. We look into the law to find out what the requirements are. We look into the facts whether those requirements are actually met. And once we've found the answer, we can then go step by step through the different requirements and actually give an answer. At the end, it's like in mathematics. At the end, you draw a long line and you say, this is the outcome. Now, in law, you have very easy cases, which are just straightforward, but there are also complicated cases. Sometimes it's complicated because the facts are complicated, but what we expect students, especially in first year, to understand is that sometimes the law is not very clear. Sometimes there are different ways of interpreting the law, which means the problem that we give will lead you to basically tumble over those complicated questions, which means you get to one of the requirements of the law where the law is not really clear. And then typically you have a dispute. The old saying is 3 lawyers, 4 opinions, of course. And you have to know these different approaches to that specific problem, which means then you are really back to the logic of an essay. You can see it this way, you can see it that way. There are good arguments for this position, there are good arguments for the other position, and you have to weigh those arguments against each other, and allow then yourself to come to a conclusion. That is your conclusion, but you have to draw a conclusion. You cannot just leave it hanging there and say, it's either this or that, and the judge will decide. No, you have to give advice on, the judge will most likely go down this road, and then continue your analysis until you finally can come to a conclusion and give an answer as to whether AG is obliged to pay me £100. Typical problems that students encounter when trying to go through this step-by-step analysis is to figure out what is actually relevant here. Because there are so many requirements that the law sets for a multitude of questions that could arise in that case, typically only very few of them actually are problematic in that case. And one of the real qualities that a good lawyer has is to go right to the point, to understand where the problem lies and then there expand on the problem. So if you spend your time trying to solve a problem on every little detail but which is unproblematic, you're wasting your time. Especially in the exam, time is precious and you don't want to waste your time on trivial questions because then you cannot show what a good lawyer you are. So one of the things that one has to train is really to focus on the real problems of that case. That, however, has a problematic side to it. And we do not all agree on that in the law department or actually among colleagues altogether. What English colleagues often suggest is to say, go right to the relevant issues, right? But it would be a mistake to just say up front, I read through the facts, and then I say the issues are this, this, and that. And then you say everything you know about this, that, and that, and then try to conclude on just that basis. It might be that you are wrong on this being the major issues. So the approach of rather saying, I don't know exactly yet what the issues are, and before you actually write down your answer, you take a lot of time to think. You think first, as I said earlier, who is claiming something? That helps you sort out the persons against whom, what are they actually seeking, right? And then you identify the legal basis on how possibly the claimant could get what they're seeking. That structures your thinking, because that opens up the list of requirements that you have to go through. And then you go through like in a checklist, right? And the easy requirements, you just check them off. And then you bundle them, you just collapse them again. You say, of course there's a contract between Jan and Agi. That is not in question. You don't have to first check, was there a valid offer? Was that offer accepted properly? Was the promise supported by consideration? And so on and so on. If all of that is clear from the facts, you just state, Agi and Jan concluded a contract. The question is whether that contract is actually valid. Because maybe Jan coerced Agi into this, and duress will allow the avoidance of the contract. So you don't just say, this is a case about duress. You will first, in your head, go through all the requirements and quickly realize, okay, there is not a problem of the actual formation of the contract as such. The contract is concluded between the two. However, it might be avoided. And you write it in that way, which means you have made sure through your checklist that you have not overseen something that the facts might suggest has happened in between. Because it's sometimes too easy to say, oh, the real issues here are this and this and that. But there could be a fourth one, or you could be wrong on one. So the methodological step-by-step approach will allow you to be sure that before you start writing, you have actually identified the right issues. And then you just have to write it down. Once you have found your structure, you have identified the issues, you know where you have to branch out, where you have to weigh arguments against each other, and then you can focus on that. That is what will give you a high grade, that you really put all of the attention to the important issues and treat the other ones, which are obvious from the facts, in a very compressed and summary way. And so basically, once you have familiarized yourself with the technique of actually solving problems, and we'll train that with you in the courses, you actually will find it's a satisfying exercise. It is nice at the end to be able to say, I advise someone, and I am capable of applying the law and giving someone the answer whether they are entitled to something or not, whether they have to be afraid of something or not, and how they can defend themselves, because I've identified exactly what the problems in the case are and what kind of argument we can then construe. And ultimately, a little bit of practice will just do that you hopefully will like problem questions, because problem questions are a real opportunity to show that you're a really good lawyer.